Very well. We can move along. Dr. Alexander, I don't think you'll need to refer back. The state has stipulated that you are an expert in your field of study based on the letter that you presented. We are here today to discuss the contents of your letter that you prepared on May the 27th, 2016. Do you have a copy of that letter with you?
Yes, I do.
Okay. And what did you do in your professional role to prepare this letter?
I used data that you supplied me. It was a series of questions about what Brandon had to drink that day.
You need to refer to him as either Mr. Vandenberg or Brandon Vandenberg, but not by his first name only, okay?
Yes, sir.
I'm sorry, Mr. Vandenberg.
Mr. Vandenberg.
So you were supplying some information. Is that what you're stating, Dr. Alexander?
Yes, it was the best recollection of what Mr. Vandenberg had to drink that day.
And you were employed by my law firm, is that correct?
Yes.
And you were employed to determine what Mr. Vandenberg's blood alcohol content would have been on this particular date. Is that true?
Yes, sir.
And your testimony is that you were supplied that information through some questions that you provided, and we provided those answers. Is that true?
Yes, sir.
Okay. Can you tell me about that process when you acquire the answers to your questions? Can you tell me about the process, how you then take that information and quantify it? And if I'm using incorrect language, just feel free to correct me.
Not a problem. There are various ways to calculate. It can be as simple as looking at a table, but that's not the route I went. I certainly looked at many different tables and many different sources of information, from Medscape to Mayo to Cleveland Clinic, etc., and settled on a Professor Forney. He's a PhD. He had given a talk in 2013 about how to retrograde, come up with a blood alcohol level. And he's got a formula that's based on Widmark's principles from many years ago. And basically, I just followed that formula.
Can you talk to us about the Widmark's data and principles that you're referring to?
Yes. It involves forming the volume of alcohol that is taken in grams. So you can, whether it's a beer or a shot of vodka or whiskey, as long as you know the alcohol content of that alcoholic drink and the number of them, you plug those numbers into the equation, convert it to milliliters, and then multiply it by 0.789, which is the specific gravity of alcohol. So that gives you the grams. Then you divide that by the weight of Mr. Vandenberg in kilograms, which is 113 approximately, and multiply that by a standard conversion factor of 0.68. That number represents a male individual's distribution of alcohol in their body, not just their bloodstream, but alcohol gets into the fatty tissues in the brain and easily crosses the cell membranes of almost all tissues in the body. So science has figured out what that is. So you take the grams divided by that 0.68 times 113, and then multiply it by 10 to get it to liters, and then you get the blood alcohol level. So when I calculated that, and there was discrepancy as far, well, not a discrepancy. What I did is I started out and I took just the numbers that I had gotten from you. But there were places where Mr. Vandenberg had said, well, I'm sure I had more. And so the number that I relied on for today was the most conservative number. And so I calculated what that blood alcohol was. And however, you have to calculate the body's metabolizing alcohol, and typically it's about 1 drink per hour. And there's a formula. It's a constant number. So you take, in this case, 14 hours from noon until 2 a.m. and you multiply it by 0.015, and you now have the blood alcohol that was metabolized and no longer present. So you take the first blood alcohol level, subtract it from the second, and then you come up with what the blood alcohol level most likely was at 2 a.m.
And this isn't the first time in your profession that you have calculated blood alcohol content and then taken that blood alcohol content and placed it in a clinical setting as to your patients or that you are consulting with. Is that true?
Correct.
Can you tell us a little bit about your experience in dealing with alcohol and the effects of alcohol on individuals?
Alcohol use is very widespread in our country, and alcohol abuse is also widespread. And with that, the interface with psychiatry and alcohol occurs in every phase of practice that I've ever had. So whether it's an outpatient private practice, outpatient in a drug and alcohol clinic, which I've worked there. I've worked inpatient drug and alcohol unit for 12 years. I was the medical director of a very large state psychiatric hospital. We had many, many people that were admitted to the hospital with different levels of intoxication. So I also served as the night call physician 1 night a week for a number of years. So I would see the people as they were brought in by the police and see the effects directly of what level of alcohol. Also, in the last 10 or 11 years, I've worked in 2 different general hospitals. So we don't have any psychiatric unit, but we see people that overdose on alcohol or get ill enough medically to come in for alcohol withdrawal. And we see people with blood alcohol levels at just about any range, but even as high as 0.5, 0.6.
And it's important for you to know as a medical doctor and in your professional role as to what degree of alcohol their body has consumed and the content of the alcohol and the effects that it would have on that individual person, right?
Yes, it sure is. You have to know, knowing what their history is really benefits knowing how to treat them and what sort of withdrawal you might anticipate.
And in fact, you knew the history that was provided to you as it relates to Mr. Vandenberg and his prior alcohol consumption, as well well as on this particular day, correct?
Yes, I did.
And how many patients would you guesstimate that you have seen during the course of your professional role that involves alcohol and the effects of alcohol on your patients?
Many thousands.
And during your testing and during your procedures as it related to Mr. Vandenberg, you were able to come up with a blood alcohol content level, is that correct?
Yes.
And what was that blood alcohol content level?
It ranged a little bit depending on what the number of drinks I put into the equation. But of the many, many times I did this, it really ended up being 0.22 is the most reliable, and that's the conservative number. So if he did have more, it could have been 0.25. But
I'm sorry.
well, I don't want to speculate beyond that because, and to be more specific, when, for example, he was given a solo cup with Jack and Coke in it, I counted it as one drink, so 1.5 ounces of Jack Daniels. But when you're on the lake and you have a big cup and you're around people that drink a good bit, there might be 2 in there. So that's why there's some spread between my conservative number and then what it might have been.
And so you most conservative figure that you could rely on. Is that correct?
Yes.
Could be higher.
Could be higher, yes.
And when you're doing this test and when you're doing this analysis, does it make a difference as to how much you are consuming at a particular time? In other words, if you consume 5 drinks right before 2 a.m. or you consume 5 drinks right before midnight, does that make a difference?
Absolutely.
And have you taken that into consideration?
Yes, sir.
And what were your findings as it relates to those types of, I'm going to call them fluctuations or variances, for lack of better words?
Well, as I stated, if you take the total drinks and you calculate out as though it was evenly spread, because that's where the equation takes you. It's just total number of drinks, percent alcohol content, and 14 hours, and this is what you get. But if you graph it, then, and in this case, he had 5 shots, maybe 6, but I used 5, back to back to back to back, just before he left Tin Roof. So his blood alcohol would have gotten much higher and probably added about 0.08 to where he was. So he was below 0.22 in that last hour, but then went up rapidly.
Okay, and when you say went up, do you, in your professional medical opinion, is there a number that you can quantify as to, based on what he drank? You know that, right? When you're talking about the 5
Yes,
shots?
sir.
And part of your analysis is to determine how much alcohol content is in a shot or in that particular whiskey drink. Is that true?
Yes.
Okay, and did you do that research?
Yes.
And what did your research conclude as to those drinks right before he had left the Tin Roof?
Well, that he was 0.25 or even a little higher than that, 0.26, 0.27.
Okay. And so 0.26 or 0.27 or 0.25 is what you have calculated Mr. Vandenberg to be after he had had those 5 shots immediately before he left the tin roof?
Yes.
Okay. And can you put that into relation into a clinical setting? What does a .25 or .22 or .27, let me back up, sorry. Part of your discussion and part of your initial report, you relied on, you had some other questions and inquiries as far as any other medications, any other type of drugs, but you also wanted to talk about, since he's an athlete, a football player, concussions, right? Tell us about that. And why does that matter?
Mr. Vandenberg told me that he had a concussion in 2010, 2011. Those were in high school. 2012, when he was a freshman and in college. And that one was significant enough that they took him out of football for 6 months. And he had to go to the hospital for evaluation in the beginning. So that told me that's pretty significant head injury. And then on his way to Vanderbilt, he had a motor vehicle accident and suffered what he thinks was another concussion. That he didn't end up going to a hospital, but he had been driving and didn't think he should drive thereafter, so his friend drove the rest of the way.
Would prior concussions to the nature as that they have been described to you, would that affect the way alcohol interacts with the mind and the brain?
It absolutely can.
Okay.
And from the information that I know and that I just spoke of, I really don't have any measurement to tell me how severe those were, like medical records from the hospital, brain scans, things of that sort. But it's certainly a factor that would have to be considered in this situation, because if you take somebody with a .22, .25, anywhere in between, or whatever the blood alcohol level is, and they have brain trauma, then the symptoms that they're going to show at that blood level are going to be exacerbated or worsened.
And I kind of got sidetracked there. You're talking about symptoms now, and we'll talk about those. So can you qualify what you would expect at a .22 or a .25 as it related to Mr. Vandenberg, and that being his most conservative, I believe you referred to, blood alcohol content on that particular night? What would come along with that?
Well, in that he is a naive drinker or a new versus somebody who has years of drinking in their background. Somebody who is a drinker can be a .22 and look a lot better than Mr. Vandenberg or other newer drinkers would look. But at that level, being unbalanced, slurred speech, difficulty making decisions, difficulty perceiving the environment, difficulty assessing situations. Basically, overall dysfunction of the brain.
When you talk about perceiving environments, what do you mean by that?
Well, specifically in this case, what was going on in his environment, even going to the apartment or driving the car. Where he parked, the things that he did the rest of the night. With a blood alcohol level of 0.22 to 0.25, you can be standing and you can be appearing to be functional and communicating effectively with people, but it's almost as though there's going to be a glaze. So it's almost like functioning on automatic. So you're there, your memory functions are going to be severely affected at that blood level. Also, you're included in your decision making, your impulsiveness is going to be very way higher than normal. Your judgment is going to be much lower than normal. So in just reading people, if there are people moving quickly, just being able to assess the speed and facial features and smiles and not smiles, all of those things are going to be impacted when you have that level of blood alcohol.
And when you say impacted to where the individual that has that degree of impairment is not able to assess those environmental situations or those stimuli as they would had they not be at 0.22 or 0.25.
Subject to leading, Your Honor, please.
All right, rephrase.
Can you elaborate on what you mean, Dr. Alexander, when you say assessing a situation in a normal setting versus assessing a situation at a 0.25 level?
For example, if someone is driving a car and they're at a 0.22 and a police officer comes over and they stop the car, but they might give the officer a credit card instead of their ID. They may give faulty answers, may not really comprehend that it's even a police officer. Maybe to some degree, see the uniform, see the badge, but maybe not comprehend the seriousness, might be laughing and joking and not really understanding that they've had so much to drink, they're getting ready to go to jail. And when they answer questions, their level of competency, for example, to agree or not agree to get a blood alcohol done, there's a very high chance that in reality they would not be able to form the intent to be able to say, yes, I want to do one, or no. They may not be able to reason why they should or shouldn't.
You use the word no, or you're saying knowing what to do?
No, as to if the officer asks the driver, are you willing to go downtown, go to the hospital and get a blood alcohol drawn, and may answer yes, may answer no, may not be able to understand why they said yes or no. And certainly when you get to the next step, which is so if I agree to have a blood alcohol done and it's high and I have to go to court, is it better for me to have been agreeable, or is it better for me to not agree and not have that piece of science there to potentially harm my case. And at that moment in time, it's that level of judgment is much decreased.
At a .22 or .25?
Absolutely.
And you and I spoke about the facts of this case. We discussed that in detail. And is it your professional opinion, beyond a degree of medical certainty, that Mr. Vandenberg was in fact impaired and that he would have possessed those inabilities to assess the situation? Is that what you're suggesting here today?
Yes, sir.
And you use the word would be incapable of, at that level, anyone at that level would be incapable of forming intent, correct?
Well, please, I'm going to object to that leading. He hadn't said anything like that at all.
Right.
It doesn't say that in his report either.
It's the form of your question. You have to ask the question properly.
Well, I think Dr. Alexander used the word intent. Was I incorrect, Dr. Alexander? Did you use the word intent?
I did use intent. I didn't say anyone, because every single case is going to be different. People are going to have different medical histories, different drinking histories, different medicines they're on or not on. And I think specifically talking about Mr. Vandenberg, my opinion is that he would not be cognizant enough to be able to form intent or to have more than first order thinking. And that goes back to that example that I was talking about, the driver. Maybe the driver can do the first order thinking, which is get my wallet and give the officer a card. Now, second order might be, which card do I give him? And therefore the wrong card. But then you get to another step, and it's, well, do I go for that blood alcohol or not? And each level of environmental cue or input that is coming in that's more difficult than the cognitive abilities just go down. So that's how someone who is highly intoxicated can appear to be functioning, talking, standing, and but in reality, if you push them with more difficult questions or more difficult situations, then the correctness of their answers and decisions are going to drop significantly.
And all of your opinions that you have expressed here today and expressed in your letter, those opinions are beyond a degree of medical certainty, is that correct?
I'm sorry?
Are based on a degree of medical certainty, is that correct? These
Yes.
are your opinions?
Yes.
1 second, please. And I may have misspoke, Dr. Alexander, when I said degree of medical certainty, a reasonable degree of medical certainty, is that correct?
Yes.
Thank you. I don't have anything further.
About 30 seconds, sir.
Stand up a second.
This is fresh water.
It's just easier.
All right, Joe.
morning, Dr. Alexander.
Good morning.
When were you hired in this case?
April?
April
Yes, sir.
of 2016, I take it.
Yes.
You remember when in April?
Early to mid.
Okay. And I think this is your letter, I guess, slash report provided.
Yes, sir. It is.
Okay. I'd like to make that an exhibit to his testimony.
All right.
And are you board certified in toxicology or neuropharmacology or any of those fields?
No, sir.
Okay. What specific training have you had in toxicology other than medical school?
Maybe some courses that I've taken, some continuing medical education, but I can't recall those from memory, and I
Okay.
can't say I've had any
So it's been a
in the
while.
last several years.
Okay. So have you had any special training in determining blood alcohol, or do you just looked at the chart like anybody else could, or the wheel that some defense attorneys use to figure approximate blood alcohol?
The vast majority of times, the blood alcohol level is known to us. Sometimes it's not. And so we will go look at a book, toxicology book, or other literature, scientific literature, and approximate what it is.
Okay. Is that letter you just made, the exhibit, is that the normal report you do in a case?
No, sir.
Okay. You normally list any testing you've done, you normally list all the information you've considered, any interviews you've done, all that type of information, don't you?
Yes, sir. But at that time, other than my conversations with Mr. Boland, that's all I had.
Okay. So you based your report basically on just what Mr. Boland told you?
Yes, and I'll clarify that by saying I asked Mr. Boland if Mr. Vandenberg had had any concussions
Okay.
and other medications, things like that. So,
But no documentation was given to you at all? All it was just a conversation that you wrote down what was said?
no, I had some documentation.
What type of documentation? Since we haven't seen it, of course, what type of documentation is that?
It was an email of a series of questions that, and the responses to the questions. So,
Okay.
like,
So you relied specifically on an email then? Do you have that copy of that email with you?
I probably do, but we might have to get on my computer to do that.
Okay. And fairly to say, I mean, you're a professional, you're a psychiatrist, you've been around a while, testified in court. That's not the normal evaluation you would do in making any finding, is it?
Not necessarily.
Okay.
If there were many times that during the course of a case that I might be involved in, I've been asked to give answers to questions early on. Then there have been times where I do, I actually meet with the individual, do testing, then do a full report based on all sorts of information that I've gathered by that point.
As a psychiatrist, excuse me, I didn't mean to cut you off.
And then sometimes I'm asked to reevaluate, or information that I felt like I needed to do a complete report comes in, and then I might even see the person a second time and then do another report. So it's not unusual for things to be piecemeal sometimes.
But this wasn't really piecemeal, it was just an email and a conversation, right? that you relied on?
Yes, sir.
And as a psychiatrist, normally the most important tool you have is the interview with the client, is it not? Your forensic interview that you do most of the time?
That depends.
Okay.
If for example, I'm evaluating somebody that has an extensive medical background, there may be many different doctors that have seen that individual. And one of the things that it's important for me to do is evaluate the consistency and veracity or validity of what they're telling me. So if they say, well, I've never had an antidepressant, never seen a psychiatrist, never had problems with anxiety, and I look back at the family doctor records, and from 10 years prior all the way up until the time of the event that I'm evaluating, they've been on several different antidepressants and been on different medications. Also looking for consistency of reports to different medical providers. Somebody could fall, hit their head, and claim a myriad of neuropsychiatric symptoms. But when they go to the ER, maybe those records don't indicate some of the things that they're saying 2 years later. Maybe much more severe symptoms 2 years later. So,
have you ever given a professional opinion in court before based on an email?
no, sir. However, the question that I was asked, I had an adequate enough information to answer that question. It was basically to use a toxicologist's, or not a toxicologist, but what is well accepted in the field of toxicology, to take that equation, take the variables that I've been provided in the email. I also asked about height and weight and got that information. So I had all the information I needed to plug into the equation.
Okay. And is it not true that when dealing with criminal defendants that you must strongly suspect malingering?
Yes, sir.
Okay. And it's hard to determine malingering from an email, is it not?
From the amount of information I was given, absolutely. I didn't have enough information to determine malingering, just that one issue.
Were you able to review any prior statements Mr. Vandenberg had given to the Vanderbilt authorities or the police department about his drinking that night?
No, sir. I had, at that point, I had very little information and very little personal knowledge of any of the cases.
And if he'd given prior inconsistent statements, would that given you concern as a psychiatrist?
Absolutely.
Okay. And you didn't review any video surveillance of his behavior during the night, did you?
I did later on.
Oh, but we're talking for this report that you're attempting to testify to.
No.
Okay. So you reviewed nothing else, no text messages, no witness interviews, nothing prior to writing your report, other than the email. Okay. And you familiar with the Journal of American Academy of Psychiatry and Law? Do you follow that journal?
That and several others,
Okay.
yes.
Are you familiar with a study that was done based in the Netherlands, reported in 2004 about alcoholic blackout for criminally relevant behavior. Obviously, you've probably read a lot of articles. You may not recall that.
I can't say that I've read that specific article.
That was a very lengthy study done. And would you agree with this statement made? Now, these are two medical doctors, two PhDs, and a medical social worker that compiled this, but they said the consumption of large amounts of alcohol may induce so-called dissociative state. Dissociation defined as disruption of the normally integrated function of consciousness, memory, identity, and motor behavior that does not necessarily cloud one's consciousness. And they go on to say that although alcohol impairs short-term memory, which may interfere with storing information about ongoing behavior, remote memory remains intact. Thus, even during a blackout, a person could be perfectly able to retrieve rules of conduct and be aware of what he is about to do wrong.
And Your Honor, I would just object if he's asking Dr. Alexander to give an opinion as to what he thinks about this particular report, then he needs to supply that journal to Mr. Alexander when he would review it in full. If he's asking him.
Well, I can. I'm just asking if he would agree with those statements.
Your Honor, please, my objection is if asking someone if he agrees to just what Mr. Thurman read, he needs the report to determine whether he agrees with that.
Well, I mean, I'll allow him to look at it.
He can look at it, that's fine.
Well, I know that from just flipping through this, for me to really answer your question well, it would take about an hour for me to read through this, and because I don't know what blood levels they're talking about, I don't know what circumstances they're talking about, and there are so many different factors. Were these people on certain medicines or have certain medical problems or have brain problems? But in an overall sense, what you're saying that this says sounds appropriate,
Okay.
but with limitations.
Okay. Now, you mentioned intent a minute ago. About what type of intent are you talking about? A person is drunk.
It would depend on what they were posed with.
Right.
So, intent to make a decision about whether one should have a blood level taken or not.
Okay.
That's a higher order question. Takes deeper thought, considering a lot of different factors, considering information that maybe their friend told them, or information they heard on a commercial on the radio from an attorney, or lots of different things. And so anytime someone is confronted with whatever the situation is and they have to make a decision, then they have to form some intent as to whether I'm going to do this or I'm not going to do this.
Okay, so you're talking about their intention to make a decision might be impaired, that their decision making might be impaired.
Absolutely.
By alcohol.
Yes, and especially at levels that I talked about earlier.
And basically, I think that's what you said in your report, that there would be an impairment with a person if, in fact, that was a true blood alcohol. And it's hard to say that with any degree of certainty based on the limited information you had. Is that correct?
Well, the first part of your question, absolutely. And a good example of that is the illegal driving limit is above 0.08. And that came about because people have impaired thinking and coordination, decision making, and certainly the science indicates that when you're up in that .20 and above, regardless of which literature or research that you go to, it very consistently indicates that there are problems with making judgments and interpreting environments, etc.
That's basically what you're saying in your report, that if it is true, this was the alcohol level of Mr. Vandenberg based on the self-serving statement you were given, and then his reasoning, impulse control would have been diminished in some, or impaired in some way. Is that what you're saying?
Correct.
Okay.
Yes, sir.
That's all the question.
All right. Anything further? Ms. Bowden?
Dr. Alexander, Mr. Thurman spoke about an email, and I believe your answer to that question was that that email included everything that you needed to form your medical expert opinion. Is that correct?
Yes, sir.
And that those
As
questions,
far as the limited question or questions that were asked of me at that time.
and that's correct. Those were questions that you asked that you needed answers to consider and to quantify Mr. Vandenberg's blood alcohol content. Is that correct?
Yes, specifically what his weight was, and then my other question was whether he had had concussions, because those can negatively impact to a greater degree whatever the blood alcohol level is.
And you indicated you were hired 1st of April, middle of April, sometime in that neighborhood, right?
Correct.
I don't have any more questions for Dr. Alexander, just brief argument, Judge.
All right. All right, you can sit down.
Your Honor, please, we probably need to introduce the CBS and CBS. Your Honor, please, may be presumptuous, but I do not think the state would agree to allow Dr. Alexander to testify, so I have tendered to the court a State v. Vaughn case, a 2008 case where the court was faced specifically with this question. This is a case where the public defender's office had given notice the week before trial, and the court actually pulled the funding, the indigent funding for an expert, and excluded, in essence, because it couldn't hire an expert, excluded that expert's testimony after notice had been given a week before trial. I'll point the court to the direction of page 14, in which Vaughn distinguished Hall. The trial court relied upon Hall when it excluded the expert testimony, and as we are well aware, we're not here talking about diminished capacity and or mental defect. We are simply here talking about voluntary intoxication. And at head note 23 on page 14, Judge, this is the Court of Appeals speaking. Furthermore, in our view, the trial court misinterpreted State v. Hall by concluding that it prescribed admission of the expert testimony proffered by the defendant. The Hall court explained that expert psychiatric testimony hearing only on personality types and character traits is not admissible, but that expert testimony showing that because of the mental disease or defect, the defendants lack the capacity to perform the mental state required to constitute the offenses for which he or she is being tried could be admissible, assuming that all other evidentiary requirements are satisfied. This holding, I'm talking about Hall, did not preclude the admission of expert psychiatric testimony bearing on the issue of voluntary intoxication as it affects an individual's ability to form the requisite mens rea to commit a crime. See Hall. Indeed, the trial court in Hall specifically ruled, and I'm moving on to the last sentence, the trial court in Hall specifically ruled that the expert in that case would have been permitted to provide testimony and opinion as to the extent of the state of intoxication of the defendant at the time of the commission of the offense. And the Hall court expressed, the High Court expressed approval of the trial court's ruling. And it goes on to talk about voluntary intoxication and how it's not an affirmative defense, and how that voluntary intoxication, when used to negate the element of the offense. Judge, I point to this case because this case was reversed and remanded back because the trial court refused to allow expert testimony as it relates to voluntary intoxication. And it distinguished Hall specifically as it relates to voluntary intoxication. I would, a few things I want to point out when we're talking about time frames here. The minute that Dr. Sid Alexander was retained by our firm, we gave notice. Although I believe, as a rebuttal witness, I didn't have to give notice, but as case in chief, we would have had to give notice. We gave that notice on April the 28th. Less than 10 days later, the state filed a motion to quash our notice of Dr. Sid Alexander. We had a hearing. This honorable court excluded Dr. Sid Alexander. It wasn't until last Tuesday, based upon our motion to reconsider, that this court agreed to allow Dr. Alexander to be pre-screened. Had six weeks when we gave notice, again, the state was on notice in 2014. They have been on notice this entire time, and I'm not going to rehash what we've already hashed, but we gave them 6 weeks notice. At that point in time when we gave notice, even though they filed a motion to quash, they could have asked this court for mental health examination as it relates to serious mental disease or defects or diminished capacity. They did not do that then. They have not done that now. They didn't do that in 2014. And State v. Vaughn has distinguished Hall as it relates to voluntary intoxication. And we ask this honorable court, it's relevant, it is absolutely relevant, and State v. Vaughn demonstrates that it is relevant and that this testimony should be allowed. We respectfully request that this honorable court reconsider and allow the testimony of Dr. Sid Alexander, Judge.
All right.
Court pleases. The court's order, final order, I think the third or fourth one, giving a deadline was December 1st of 2015 for all expert names and reports. The state got this letter/report on a Tuesday, 1 week before he left for Memphis for jury selection. The court had previously denied this expert testifying, and we had a hearing, or had the motion to reconsider on a Monday before we start the trial on Wednesday by selecting the jury. Defense counsel totally ignored the orders of this court, totally ignored the rules of criminal procedure to gain a tactical advantage. And I've been in this case for 3 years. I think it's the most passionate I've felt about a motion in a long time. This is total trial by ambush. To allow this testimony denies the victim's constitutional right to a fair trial, denies the state of Tennessee its right to a fair trial. Their action in this case denied the state's ability to hire their own expert to either rebut the testimony of Dr. Alexander or to help us on cross-examination, and to think we could go out and hire an expert based on a name when we don't even know what he's going to say is a ridiculous argument. They denied us our right to have an evaluation done because we could not hire an expert. If you look at Rule 12.2, it's very serious about the defendant's failure to comply with the state's right to evaluation, and says that the testimony of their expert could be disallowed based on that alone. Now, obviously, they haven't refused to have him evaluated because of their tactical decision to wait till the last second. The state's deprived of their right to even have an expert to evaluate him. But they have circumvented the state's right to an evaluation, which that alone can allow the court to not allow this testimony. Can we have meaningful cross-examination? We just now got a CV today. I haven't had a chance to look at it. We had no information that was relied on because evidently there's nothing but an email that we haven't seen yet. Now we know what test he did. Here we are starting our trial today. And also they denied the state's right to appeal. If they'd given notice on December 1st, we could have had this hearing in January. And if the court had granted Dr. Alexander to testify, which we think is against the case law in Tennessee, then the state would have at least a right to request a Rule 9 or take a Rule 10 and have that ruling done prior to the trial today. That's denied. I submit Dr. Alexander's testimony is not admissible under Tennessee law. You look at Hall and all the cases, Farrell, Faulkner, and the two cases I cited were more recent than the one they cited, Wilson and the Banksy case, clearly say that the expert must say it's a lack of capacity, not speculate on impairment, not diminish capacity, which the courts have said over and over, at least our Supreme Court has. There's no such defense as diminished capacity. It's got to be a lack of capacity. And the case they cited, that was a case where Dr. Caruso said in his opinion the defendant could not have the capacity to premeditate. This doctor doesn't say that. Of course, he couldn't. He doesn't have enough information. He says, based on his report, and I think the testimony today, there would have been impairment, obviously, that we all know, and a lack of functioning. But that's not what the law requires. I think the law was clarified under LaSergio Wilson, my case, and also the Bonsky case, where they addressed the very same issue and said the expert has to say it's a lack of capacity to form, in this particular case, a knowing intent, which was never brought up with this doctor. He never gave an opinion on anything saying that he lacked the capacity to form a knowing intent. Also, your court looks, there's another issue, is this necessary to substantially assist jurors? And they were voir dire extensively on just what this doctor said. Yes, your functioning would be impaired. Yes, your thought process would be impaired. Your decision making may be impaired. But all the jurors said, yeah, everybody knows that. They all agreed. They voir dire the jury on this exact same, what this doctor is trying to testify. It's not necessary to substantially assist the jury. The Vaughn case, they testified, even though Dr. Caruso said he lacked the capacity to form, it was a PCP case, which not every juror knows how PCP would affect a person. But I think every juror in voir dire explained they understand how alcohol may affect your decision making, but that's not a defense. A defense is a total lack of capacity. Being able to have a knowing intent, which basically is an awareness statute that you're aware of the facts or the circumstances around you. And is this, the third thing, is this based on reliable information? Can you really, when this doctor has not looked at a single witness statement, has not viewed anything, all he's gotten is an email on self-serving statement from Mr. Vandenberg, who the court has heard testimony about statements he gave the police. I think of Vanderbilt, which totally contradict what he told this doctor, evidently, or Mr. Boland told the doctor, whoever told the doctor. It's strictly self-report, and the doctor acknowledged that if that would give me pause if there were different statements had been given by this person. So it's his previous unreliable testimony or statements given, I think, are crucial here, plus the lack of all the other factors a doctor could have considered in this, that I think this opinion, clearly based on an email, which the state has never seen, is not sufficient reliable information to allow an expert to testify. Since Your Honor has allowed this proffer, I don't think there's any issue in ineffective assistance to counsel, since I think clearly this expert had been hired on time. It would still been inadmissible under state law, Tennessee. There's been argument about rebuttal. This would be a rebuttal witness, and he says they don't have to give notice. Well, he cited no case that I've seen. We filed a notice of authority with the court today discussing this. Obviously, a mental state is an issue in every case except where there's strict liability, and you would be able to say everything's rebuttal. There would need to be Rule 16, Rule 12. There wouldn't need to be all the case law excluding experts, because everybody would just be a rebuttal. Take an alibi witness. His theory is the state calls in two guys, say, yeah, I saw him rob the liquor store, then they could put on an alibi witness and rebuttal. And that's not the law, and it's not the law in the state. If you look at Nice versus State and State versus Green, two cases that I provided for the court on page 6, and Bonsky, even the other case we've already previously cited for the case on page 27, it defines rebuttal evidence in Tennessee. Any competent evidence which explains or is indirect reply to or a contradiction of material evidence introduced by the accused, or which is brought out on his cross-examination. So this is not rebuttal evidence, Your Honor, please. There's no such thing as rebuttal evidence for the defense. It's only SIR rebuttal, or they would rebut the state's rebuttal. And the purpose of that is because the state has no way to know what their defense is going to be. So the right to put on a defense we talked about, clearly in Chambers versus U.S., a U.S. Supreme Court case cited in a Mays case, the right to present a defense is not without limits. The Supreme Court has observed that the accused, as required by the state, must comply with established rules of procedure and evidence. And it's clearly has not been done in this case, Your Honor, please. To allow this testimony is fundamentally unfair, and it clearly does not promote the fairness in the administration of justice in this case, which has been pending for now almost 3 years. And here we are the day of trial arguing about an expert. It's just not admissible under the law.
Final word.
Maybe the rub is that the state tends to believe that we're talking about an affirmative defense, that we're talking about the same measures as an alibi or an insanity defense. That is not the case here. And I point the court to page 15 of the Vaughn case, and it's very clear in the 2 paragraphs to the left of the conclusion. Consequently, we conclude that expert testimony bearing on the issue of whether the defendant was intoxicated was relevant and properly admissible under Hall. The 6th Amendment and the Due Process Clause of the 14th Amendment to the United States Constitution clearly guarantees a criminal defendant the right to present a defense. It is relevant. Dr. Sid Alexander will testify as to the intoxication of Mr. Vandenberg. Whether the jury knows about intoxication and brings their own life experiences into the courtroom is one thing, and I point again to that same paragraph under consequently. The questions of whether the defendant in this case, same paragraph beginning with consequentially, in this case was under the influence of PCP at the time of the offense, and if so, whether his intoxication had any bearing on his ability to premeditate and form the intent to kill, were questions appropriate for the jury's consideration. This is appropriate for the jury's consideration. And Judge, as it relates to rebuttal, the state, Mr. Thurman, keeps saying we have provided no authority. Our response to their motion to quash is littered with authority when it talks about rebuttal evidence. I'm sitting here looking at a case that I cite, State v. Husky, and it clearly cites, and this is in our response, it depends on whether the defendant intends to introduce or call a particular witness at trial. State v. Husky, 1998 Knoxville case. I can go on. I lay it out very handsomely. State v. Harrison, that's in our response. So for the state to suggest we haven't cited authority, we have cited authority as it relates to rebuttal evidence. If a witness were to get on that stand and say, Mr. Vandenberg seemed fine to me, wasn't acting out of the ordinary, wasn't stumbling, then we cannot be prohibited from rebutting that testimony to any degree, whether it come in the form of lay testimony or whether it come in the form of expert testimony. We can rebut that testimony. We respectfully request that this court allowed Dr. Alexander. You know, there's talk that Mr. Boland has threatened the court with this ineffective assistance of counsel. The reason that's important, and actually the Vaughn case talks about this, they missed a deadline, and the trial court extended the deadline because they knew what the ramifications for that may be. The reason that's important, the state's first argument is Mr. Boland missed a deadline, Mr. Perez missed a deadline, Mr. Reagan missed a deadline. We've not known about this. We didn't have an opportunity to evaluate the defendant. Since 2014, all they would have had to do when they first got served the notice was to file a request to have the defendant evaluated. If they didn't want to do it then, when we served notice out of an abundance of caution, if the state wasn't presumptuous that this court was going to quash our notice of expert, they could have filed then 6 weeks ago. So to suggest that, well, now we don't have time to do that, Judge, well, sure they've got time to do that. Out of the interest of justice, this court can take all kinds of measures to allow them the time and opportunity to do that. They never asked. They have never asked. They haven't asked today. They didn't ask 6 weeks ago when we gave them notice. They didn't ask 2 years ago when we gave them notice. And they talk about all this self-serving statement. Well, I would submit to the court that Dr. Furslow, who has been on their expert witness list since the first trial in this case, was given self-serving reports. He has not interviewed anybody in this case. Those reports were relied on by information provided by the District Attorney General's office to Dr. Furslow. It's a pot calling the kettle black. They give them information. He relied on that informing his report. Judge, we would ask that our motion to allow, or our notice not be quashed, that it be reconsidered, and Dr. Sid Alexander be allowed to testify in accordance with State v. Vandenberg.
All right, thank you both. Well, I did allow Dr. Alexander to come to present what he had with respect to the issue of intoxication and possible diminished capacity. And I listened to the testimony and reviewed a number of cases such as Neese, Bonsky, Hall, Wilson, and somewhat of a review of Vaughn, as pointed out by the defense this morning. And the court thinks there are three things that are really important in this particular case. First and foremost, the state put forth the argument that it did not have a chance to have an expert to rebut Dr. Alexander, and that's pretty much true. Keeping in mind that, as pointed out by the defense, that the state did not provide an expert to evaluate Mr. Vandenberg. Well, neither did the defense. Dr. Alexander did not do an evaluation, as far as I can tell, by the testimony presented today, of Mr. Vandenberg. The second thing is that Dr. Alexander was admitted to testify, or allowed to testify, as an expert in psychiatry, but upon cross-examination, he did not demonstrate any particular expertise in the field of toxicology, which this court believes is extremely important. If you're going to testify about one's level of intoxication, you should have some specialized knowledge in toxicology. That was not demonstrated here. Thirdly, his conclusions and opinions were based upon information supplied by defense counsel as admitted in the form of an email, and not based upon any scientific information or documented information or any particular evaluation that he had provided. As such, the court believes that the underlying facts indicate a lack of trustworthiness in this particular case. And taking all those factors into consideration, the court is of the opinion that Dr. Alexander's testimony should not be allowed. We're going to take about a 5-minute break before we get started.
All rise. We're in a 5